All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having to speak before this court are admonished to draw nigh and give their attention to the court now sitting.
Please be seated. Good morning and welcome to the Kansas Supreme Court. I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 a.m. docket.
Thank you. The first case on the 9 a.m. docket for Friday, September 15th, 2023 is appeal number 123723, State of Kansas versus Melissa C. Lowe, Sedgwick County, briefs both sides.
May it please the court, Carol Long and Eckerschmidt on behalf of the appellant, Melissa Lowe, present and ready for argument.
Morning, may it please the court, Assistant District Attorney Gillette on behalf of the state of Kansas, present and ready for argument.
Second case is CCR number 1392, In re Dana Burkdoll, matter in court reporter discipline, briefs both sides.
Good morning, Todd Thompson as Special Disciplinary Counsel for the State Board of Examiners of Court Reporters, present and ready for argument.
Good morning, Jim Biggs on behalf of the respondent, Dana Burkdoll, ready to argue. Thank you.
Your Honor, that concludes our 9 a.m. docket.
We'll ask counsel to please come forward in 123723, State v. Lowe.
Good morning, may it please the court, Carol Long and Eckerschmidt on behalf of the appellant, Melissa Lowe. Chief Justice, if I may, could I have 3 minutes for rebuttal?
3 minutes is granted.
Thank you. This case comes before this court after a Sedgwick County jury convicted my client of 1 count of aggravated assault based on an incident occurring in a parking lot between my client and a woman dating her ex-husband, occurring after a youth softball game. The jury convicted my client. She appealed. On appeal, we raised 2 issues. Whether there was sufficient evidence for the jury to convict my client of aggravated assault. And the second issue was that the district court erred in failing to instruct the jury on the lesser included offense of simple assault. The Court of Appeals affirmed, and we filed a petition for review on the second issue, and that is the issue before the court today, whether the district court erred in failing to instruct the jury on simple assault. Our argument is fairly, I never want to say fairly straightforward, but our argument is that the Court of Appeals relied on rationale that is inconsistent with prior case law from this court and from the Court of Appeals. The Court of Appeals analysis as to why a simple assault instruction was not factually appropriate was fairly brief and was simply that Ms. Lowe's defense was that she didn't do it. The incident didn't occur in the way that the state was alleging. She did not intend to place Ms. Logsden in fear of bodily harm. And so therefore, either it happened or it didn't happen. And a lesser included instruction on assault would be inconsistent with her defense. But that's counter to case law from this court that I cited in my petition, specifically State v. Williams, that says that inconsistent defense is not a reason in and of itself to not instruct on a lesser included offense. The Court of Appeals opinion also in the first section on sufficiency of the evidence it appears to adopt a definition of deadly weapon that is used in aggravated battery cases, not aggravated assault cases. And they don't specifically mention that definition again in the second issue, under the analysis of the instructional issue. But so I'm not going to assume that they were relying on that definition. But it's hard to see how they would reach their conclusion without relying on that definition. That definition argument is incorrect. They are relying on a definition of deadly weapon that is objective, that is in the context of aggravated battery. Here we're in aggravated assault, and just as the PIC instruction instructs, that is a subjective, that can be, there's two ways to show that an object was a deadly weapon, and one of them is a subjective test. So interwoven with our argument that the Court of Appeals ignored precedent from this court about inconsistent offenses is that they are ignoring the fact that a car is not always a deadly weapon. It depends on how it's used. And that's a highly factual question, and our argument is that should have gone to the jury. The Court of Appeals didn't even get to clear error, but I will address that briefly here. So it is correct that defense counsel below did not request a simple assault instruction, nor did he object to the instructions as a whole, I don't believe. So we're dealing with the clear error standard. So what I need to show or argue to your honors is that this court can be firmly convinced that the result would have been different. I'm not necessarily arguing that each and every juror would have chosen simple assault if they were instructed on that. I just have to show that the result would have been different. So that could be a conviction for simple assault, or it could have been a hung jury. That would be a different result. And all that would have taken is one juror to look at the simple assault instruction and say, this fits a little bit better. This is better than aggravated assault.
What were the facts about how the vehicle was used? That seems directly relevant to me to your argument you're making.
Yes. So the facts are they're not drastically inconsistent, but the facts are that my client was driving a little bit faster than typically in a car drives in the parking lot, somewhere between the mile per hour of 5 and 15 was quoted. It varied. I think there was so the testimony that was not in her favor was generally she was driving a little faster than normal. I didn't see any testimony at trial that indicated she was driving 50 miles an hour. In terms of a specific mile per hour, I believe 15 is the top mile per hour number that was introduced at trial. In terms of proximity, that varies a little bit too. The victim testified that she had some sort of comment about if she had been wearing a belt, the car would have touched her. The car did not touch her. So it's, it's not clear to me based on those facts that the car was used as a deadly weapon. It's a factual question up to the jury. So that's one way to show deadly weapon, that the car was used in that manner. But the other way is to show that my client intended to make the victim think it was a deadly weapon and that the victim believed it was a deadly weapon. And I have not seen any testimony at trial indicating that the victim thought she was going to die or I believe it suffer serious bodily injury. So that option for proving deadly weapon is out. And the first one about how the car was actually used, whether it was calculated, used in a manner that was likely to produce death or serious bodily injury, that's up to the jury to decide. And my argument is that this court can be firmly convinced that at least one juror would not have believed that. And
Go ahead.
Just how do we, I agree with you that that's our standard, but it's been a bit of a curious standard to me in the sense of how do we get there? Like, what is the mental process that you're asking us to go through to
well,
reach that conclusion?
I'm not asking this court to reweigh the evidence, because that's not what appellate courts do.
Well, you anticipate my question. I mean,
Yes,
isn't that exactly what?
It is, and
happens?
I don't know.
Here's the problem I've got. Aside from what the daughters said, what the women said, you've got you've got an outside witness. This Brandon Burleson, who testifies that the car, quote, tried to hit the group of people that was walking. Now, that's as direct as you can be, that she was aiming the car at these people. And the jury unanimously convicted here. So I don't see how it's just speculative that someone might have thought somehow, but your burden for clear error is that the jury would have reached a different verdict. And the would have part just requires, it seems to me, too much speculation. Because you don't really have anything to hang your hat on. I don't think. It's not just a credibility. I mean, there's a lot of credibility fight here, but the jury made that this determination
Yes, so
unanimously. I'm just trying to get this out of the realm of woulda,
right.
would have versus mighta, coulda. On a good day, we get a jury nullification because this is just a silly event. That it seems to me that's what your argument is.
So-
Once you get to clear error.
So there's always going to be some speculation with juries because they do bizarre things. And my best argument is twofold. One, so Burleson, I believe, or the sort of more neutral witness testified, right, that the car was trying to hit them. But we still have to consider testimony about speed. For example, another set of facts that I have experienced personally, not personally, but in a case, car is backing up, rolls over a victim's foot. The issue is whether the driver's foot slipped off the pedal or was slipped off the brake or was actually pushing on the gas, whether it was an accident or intentional. So rolls over her foot, did not suffer any broken bones, suffered only bruising miraculously. Is that situation, the car in that situation being used as a deadly weapon? I mean, that's a little bit different than ours where he's saying the car was being driven, but the speed I think is important here. And as I was driving into the parking lot here this morning, I'm not presenting evidence. This is just kind of anecdotal here. I think I was driving 10 to 15 miles an hour. Maybe that was too fast, but it didn't feel that fast. And so just in and of itself, a car making contact with somebody at that rate, that's a question for the jury to decide. It's not clear to me that that would cause death or serious bodily injury. Anytime you're doing this reversibility analysis, there's some speculation, and I don't know what the answer is to that. You can have all the evidence of the world that to many outside observers would think, yes, this is going to result in a guilty verdict beyond a reasonable doubt, and then the jury doesn't do it. And I don't have an answer for how this court avoids at least some speculation when you're engaging in a reversibility analysis, regardless of whether we're doing it with clear error or the lesser standard when an instruction is requested.
You've sort of,
Go ahead.
I was going to say, you've sort of focused in on the moments of the near impact or slight impact, depending on which version of the testimony you believe. But is it also relevant in our reversibility analysis, if we get that far, to look at the entire context? We're talking about a family dynamic here, where you've got a new girlfriend of an ex-wife a verbal altercation that occurs beforehand. At least there's evidence, some evidence to that extent, some anger already being generated. All of that precipitating. Don't we have to also consider that context as part of a reversibility inquiry? Or do you think that's outside the scope of that aggravated element?
No, I think that's within the scope, inside the scope of this court's consideration. I don't think it necessarily leads to the conclusion that the car was used as a deadly weapon. It certainly shows, conflict, anger, a reaction. But does that mean that she used the car in a way that was calculated to create death or serious bodily injury? Or that she was so mad that she was trying to make the girlfriend, believe she was about to die. So I believe it is, but I don't necessarily think it means that this court can't reverse.
But in assault, the intent isn't to actually kill her or seriously injure her. The intent is to place her in fear of that.
Yes, when I'm talking about the intent, I'm talking about the definition of deadly weapon that's relied on in aggravated assault. So,
Right, but somebody who commits assault can walk that line that I'm not going to hurt you, but I'm going to make you worry that you're
right. And so I think right. And so that's really the some evidence that exists that justifies the lesser included assault instruction. So that's the argument, is that maybe she was trying to, scare her. But was she trying to scare her so much that she thought she was going to die? And did the victim think she was going to die or be seriously harmed? That second part, that's what's needed for the aggravated assault to prove the deadly weapon. Either that, or that the car was used in a manner that would have created death or serious bodily injury. Or at least that's how I'm reading. An object can be a deadly weapon if the user intended to convince a person that it is a deadly weapon and that the person reasonably believed it to be a deadly. That's my understanding of how that works. I'm not sure if I answered your question.
And a factual question, and was there any evidence that the victim took any action to avoid collision, like jumped out of the way? Or I remember there was something about pushing your hand out, but obviously you're not going to push a car away from you. It was there. Some witnesses, I think, described it as a thump, almost as an angry reaction to what had occurred more than a preventive action.
That's
But,
yeah, that's as Your Honor was asking the question, that my only memory is somebody, and I can't remember who, reached out and touched the car. But I don't recall any evidence that she jumped out of the way or had to dive out of the way. Just that the car came. There's a question about how close, and somebody put out their arm and touched it. And I don't know if that's in an anger type motion or.
And what is the evidence? I remember some testimony about hearing the car the wheel spinning.
Right.
But was there any evidence about her visualizing anything before the car was right there?
The victim seat, like kind of
Victim, yes, I'm sorry.
I don't think so. I don't recall specifically. I think it was more or less there was the car. Multiple people testified about the sound and the tire spinning. But yeah, I apologize, Your Honor. I can't recall if there's any more specific testimony about visually what the victim saw.
When the car was seen, it was nearby with some discrepancy about how near, but it wasn't in contact.
Yes, that's correct. Yeah.
Is there anything in the record that indicates why the lesser was not requested?
Not that I'm aware of. I don't recall defense counsel saying we're going for an all or nothing defense. He just not requested. See, my time is up. Simply request that this court reverse the Court of Appeals and remand for a new trial.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. The only issue here today is clear error and how that test works.
That mean you concede the Court of Appeals erred in as to whether simple assault should have been given, was required to be given?
No, I don't, because that would be the third step in I guess what we consider the clear error review is that whether or not that lesser would have been factually appropriate. And the state does not believe that it would have been.
Why?
I see how you're sequencing, but
Yeah.
Yeah, but tell me why. I mean, haven't we been clear for the I mean, I might have been on a different side of that issue, but isn't it clear by now that the lesser is almost all, as long as sufficiency is the standard? And are you gonna get up here and say, had they convicted of simple assault, there would have been insufficient evidence of that? That's our test.
And I think frankly, I think it's possible. And I think had a jury convicted of simple assault, we would have a defendant here that is making that argument today, certainly. And I think that's the problem.
but this gets to Justice Rosen's question. But just to back up a second, you agree that the elements of simple assault are the same elements as ag assault, except for the last element, which is the use of the deadly weapon, right?
Correct.
And you're arguing, and you're telling us that you have sufficient evidence to capture those first four elements for ag assault. So by definition, there's sufficient evidence to support a simple assault instruction, because all of the elements of simple assault are covered by your evidence. Because it has to be, or else you don't get the other conviction.
And I think if I may, I think this is a case where I think in this court's analysis and application of the clear error test, this is the case that proves that test ultimately does break down, because courts are to view the evidence in the light most favorable to the defendant regarding a lesser. And that test becomes unworkable here because the statutory test requires that there is some evidence which would reasonably justify the conviction of the lesser. And that's an instruction that the district court has the duty, or that's a statute that the district court has the duty to apply prior to and instructing the jury. And what we had here is a defendant that presented a unified defense. Did the defense attorney clearly, explicitly state, I'm presenting a unified defense? No. But if we apply that standard and we review the evidence in the light most favorable to the defendant here, she's not guilty. That was her evidence. That was her argument below. And so what we end up with is just pure speculation here. We're trying to.
And that's enough.
Huh?
That's enough under our case.
I actually respectfully disagree, because the case law requires if a defendant is going to pursue inconsistent defenses, they actually have to pursue them. That did not happen here. That just clearly did not happen here.
Is part of the problem the matter of impossibility? I mean, this is a car. And can a car ever not be a deadly weapon when it is the instrument being used?
I suppose there may be a factual scenario that exists that it would not be. It's a little bit hard to envision, though, frankly. I think the case law, there are plenty of case law examples where cars have been used to commit aggravated assault, aggravated batteries, even homicides. But there is always a question about how that car would be used. Some of the questions that were proposed, I think you have to take into account the full context that there was a contentious history, child custody case going on, an angry defendant who dislikes her ex-husband's new girlfriend. The evidence was that she stares her down as they're coming out of this ballpark. There are angry words exchanged. She then, according to all of the state's evidence, she then accelerates the car directly at the victim in this case. The car comes within arm's length to within practically scraping the body of the victim in this case. Finger raised in the air as the defendant drives away. Her own daughter thought she was going to hit the victim in this case. Sad and ongoing custody. And the jury resolved minuscule credibility finding there that this was a deadly weapon.
But the problem is, you're saying in the instruction conference, you want the judge to decide those facts so that the jury is not given the simple assault instruction.
I'm saying that that is what the statute requires. The statute requires that there be some evidence which would reasonably justify a conviction for the lesser. I'm
And
afraid
you're aware of at least a 10-year history of the majority of this court rejecting that argument, aren't you?
I am, but I think that, again, this is the case that proves that breaks, this last 10 years, this is a case where that test breaks down.
Why is it unreasonable to believe that a jury might accept sufficient evidence?
This is where we get into where the test was just before the last 10 years, something that's clearly of the higher degree. This is a case, but I know we've strayed away
Well, I
from
mean,
that.
I'm thinking back at least my history with this issue. I think it even is longer than 10 years ago.
Yeah.
But
11 or
anyway,
12, I think I cited that. I don't remember if it was Seba or Rodriguez, and we cited that in the brief, but the evidence here is that this was an aggravated assault or nothing. There's no in between here. There was never any in between supported by the evidence. There was never any in between supported by the argument. She either did this with the deadly weapon or she didn't do it at all.
Why is
And-
it nothing when you just said that a car can be used as something other than a deadly weapon?
But you have to consider what's the evidence is in this case, and that's the reasonably prong that's presented under the statute. And again, if we view the evidence, if this court views the evidence in light most favorable to the defendant, as the clear error and standard requires it to do, she's not guilty.
Was there any evidence as to how fast the car was going?
The evidence was that it was between 5 and 15 miles an hour, depending on the perspective of the various witnesses. But that it was unreasonably fast, that the tires were spinning. That was the evidence. And the evidence was also that so the car came at the victim from behind, slightly behind her, and it came up fast enough that she was barely able to react. I think that was the
Miles an hour isn't really very fast though, is it?
5 miles. Well,
I mean, what would happen? Was there any evidence as to what would happen if somebody's hit by a car at 5 miles an hour if they see it coming?
that's the difference between an assault and a battery, frankly. Because anything basically could happen. If she goes down, the car rolls over her. Maybe it keeps going, maybe it stops and sits on her and kills her.
Can I ask a follow-up to that?
Sure.
But move us from factually appropriate into the clear error part of the analysis. And the test is, would we be firmly convinced the result would have been different? You agree with that, right?
Correct.
I'm going to ask you the same question, ask opposing counsel. Help me understand what your position is as to how an appellate judge is supposed to answer that question. In other words, what is the analytical process? What steps do we go through?
That's where I think this is the case that demonstrates that test seems to break down, because it is purely a speculative reweighing of the evidence.
Okay, so along those lines, let me give you one possibility and then ask you to react to it. If I imagine myself to be a juror hearing all of this evidence, and I think to myself, I would have convicted for simple assault. Does that mean I am firmly convinced the result would have been different?
I just don't think so, Your Honor. I don't think that that's,
Give me an alternative.
well,
give me
what
a
I would say
different
is
way to
that
answer.
if that is the test, then courts have to give lessers in every single case.
No, I'm asking you to assume the lesser is given.
Right.
And I'm trying to resolve the difficult question of how judges are supposed to conduct, for lack of a better word, the prejudice prong of the analysis.
I don't see, well, I think you would have to have you may have to have an instance where there is actually direct evidence that that would support the lesser, independent of or standing free from the charged crime. Basically a factual scenario that's not this case where it's either all or nothing. I believe
Why couldn't a jury just think the car was not being used as a deadly weapon here?
because I don't believe, because that wasn't the evidence that was presented. The evidence was presented was that it was either being used as a deadly weapon. That was the state's perspective. That was the testimony from all of the state's witnesses, or it just didn't happen.
I understand that, but if the lesser was given, the issue would have been joined with the jury. You're just back arguing the lesser shouldn't have been given. I'm trying to get you to assume the lesser was given.
And I think what maybe what we're talking about is that the statute, or what we're talking about here is that basically it's flip sides of the same coin. The test is whether there's some evidence that would reasonably justify it, but there cannot be some evidence that would not make it reasonable. Trying to articulate this here, where it is a case where something is clearly of the higher degree, basically. The old test, I think, was more accurate, more consistent with the statute. And basically the state's position, and it was argued yesterday that a court needs to look at this neutrally. And that, I guess, is part of the problem is the statute is telling the district court how to instruct a jury before they reach a decision. This court has, in our clear error analysis, has now strayed into just a pure speculative reweighing and doing it in the light most favorable to a defendant, which doesn't make sense. And this case proves that that fails, because in the light most favorable to the defendant, again, here, she's not guilty.
You have an alternative. If you don't like firmly convinced, the result would have been different. Do you have an alternative proposal?
Frankly, I guess I hadn't thought about that, because that would be the appropriate standard, but I think the question is, how do we get there?
You're focused again on not giving the lesser. Is that what you mean by that?
At least in part, and then we have to have, I think that we have to have a neutral review of the record. We don't view things just purely in the light most favorable to a defendant, because that puts us in a position where a defendant can, as they did here, present a unified defense and then run to this court and offer nothing but rampant speculation that is a change of position.
But I also heard you say we need to be neutral. And to me, that becomes putting us in a position of weighing facts, as opposed to just saying, was there, if we look at it in the light most favorable to the defendant, was there sufficient evidence? And that to me is the most neutral way for an appellate court to look at the case.
And I would have to respectfully disagree, because light most favorable clearly indicates that this court is reweighing things. We are putting weight on evidence to try to look at it in a post hoc fashion, where this court needs to review things in a neutral manner, look at the whole record.
And I concede that if we look at, we could choose to, but I think it would be contrary to some other principles, but we could choose to look at it at the most favorable to the state. But when we do that, we're not trying to say, okay, this is how the jury would sift through the conflicting evidence. And I guess that's more my point is that what it seems to be that what you're asking us to do is to try to predict how the jury would look at conflicts in evidence. And I just don't see how, as an appellate court, we can do that. I think we,
Well,
in
I
my
think-
view, picking one side or the other to look at it in the light most favorable then causes us not to really resolve conflicts.
But I think this court's fully capable of looking at things neutrally to consider and look at things from the district court's position prior to instructing the jury and say, look, is there some evidence which would reasonably justify a conviction? That's not what's been happening. What's been happening is we're not saying, is there some evidence that could reasonably justify a conviction? We're saying, is there some evidence viewed in the light most favorable to the defendant that in some hypothetical world might or maybe could get us to a different result?
Can you?
Even a hung jury, as I've heard today, would be sufficient. And that is just rampant speculation.
Consider this, since the statute is worded like that, some evidence to reasonably justify. That's a directive to the court, to the district court. Is our proper review then to review what the district court did under an abuse of discretion standard, to whether the court's action was reasonable?
I think that would be a fair way to look at this, yes. And in doing so, looking at the evidence neutrally, rather than in the light most favorable to one party or another. I'm not here asking this court to give the state any undue favors or benefits. We're saying, look at it neutrally. Could it reasonably justify? Could it reasonably justify a conviction of the lesser? And I'll circle back, because as I said earlier, had this misdemeanor instruction been given here and the defendant been convicted of it, I have no doubt we would be before this court with a defendant arguing there was not sufficient evidence to justify that because it was clearly of the higher degree. Because that was her argument below, was that there was no evidence of any crime. So she would be here saying, either continuing to say that or again changing position to say there wasn't any evidence of the misdemeanor because there was only evidence of the greater. And the jury would have convicted me of the greater, so I should walk.
Well, what have we done in cases like that? For example, where the state proved a higher quantity of possession with intent to distribute narcotics, but was charged with a lower quantity. How has this court resolved that?
I apologize. I'm not sure
Well,
off the top of my
I think
head.
we've kind of taken the same position consistently, and I believe that, well, if you have a quantity to support a greater conviction, it was necessarily sufficient to support the lesser conviction.
And I think that's a little bit of a different circumstance, if I may, when we're talking about. I think that actually may be a good example of neutrally looking at the evidence, because in that circumstance, we're talking about a weight. That is something that cannot be skewed one way or another.
Yes, it was just to address your hypothetical about how, yeah, I get your point.
But I mean, I could see a defendant making a similar argument here, but I see I'm out of time. I would simply respectfully ask if there are no further questions that this court uphold the ruling of the Court of Appeals stating that the lesser included instruction for simple assault was not warranted here. And then I would argue that in the alternative, even if that instruction had been given, that the failure to give it was not clear error under the facts of this case. Thank you, Your Honors.
I've been racking my brain trying to come up with a better definition or analytical framework for clear error, and I cannot offer one to this court.
You heard my question, is my rumination that if I think to myself, well, if I had been in that jury box, I would have found simple assault. Is that the right rubric?
it might be all you have. I don't know. I mean, we're all, I think it's impossible to, so you have reviewing the facts and the evidence, and then you have weighing them or attributing more value or credibility to some than others. And that's right, because the justices here are not in the district court. We don't see the expressions, and it's hard for an appellate court to evaluate credibility and assign more weight to, some evidence than the other. So that's out. But there has to be some sort of analysis or conclusions about the evidence. And I don't know what test to use other than that seems reasonable to me. I've often looked at the firmly convinced language and thought that standard sometimes is interpreted to be so high that the only way a court can be firmly convinced is if there's testimony that the jury asked a question and said, can we convict on a lesser? We would have convicted on a lesser if we had been instructed on this. Well, we got firmly convinced, but I've never seen that. So I don't think this court's going to get that level of firmly convincing. So Your Honor, perhaps it is, well, I would have done that.
Can you address the question that I had before? Since the statute directs the district court judge to determine whether there is some evidence to reasonably justify a lesser, is our appropriate standard of review here the abuse of discretion standard?
I don't know. And this has always perplexed me a little bit, that the standard of review for these instructional issues is not necessarily always a standard of reviewing court's decision. I don't know.
I don't think we have any guidance either, like from the Strickland prejudice inquiry. I was trying to even think it's a different standard, but it's still calling on us to sort of do that, evaluation of the record, and how would the jury have decided it in a hypothetical world. But maybe I haven't looked at it. Can you think anything from that line of case law to guide that would be applicable to our reversibility inquiry for clear error?
There always seems to be some human element of the judge or justice evaluating in some form the evidence. I know, Your Honor, I just request that this court reverse.
Thank you. Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement. We'll now call CCR number 1392, In re Dana Burkdoll.
Good morning. I'm Todd Thompson. I am the appointed disciplinary counsel for the State Board of Examiners of Court Reporters. I would request 2 minutes for possible rebuttal. This disciplinary matter arises from 3 separate complaints in 3 separate cases from 3 different people. But they are consistent in that they all involve the repeated failure to timely produce transcripts and the repeated promises that were not met. The result was delayed trials, significant problems for the parties and the trial courts. For example, a 6-month delay in a deadline for filing dispositive motions, an 8-month delay before a trial could be held and had to be rescheduled. So the results were significant. The repeated requests and repeated broken promises. For example, in the Gibbons complaint, there were over a dozen requests and promises that were not met. The same was similar for McCray and for the Attorney General's office complaint. Now, once the complaints were filed, the respondent has been very cooperative. She admitted the allegations. She stipulated to facts to expedite the hearing. There really was no dispute about any of the material facts. And the board recommended a 12-month probation with quarterly reports indicating essentially how she was doing on getting transcripts turned around. Some of the complainants thought that the quarterly reporting was not frequent enough. So we filed a brief and suggested that perhaps this court require monthly reports to a third party so that respondent could be
What's the
monitored.
third party bit of that? You don't like the recommendation that the reports go to the board?
The reports can go to the board. The problem is the board does not really have a permanent staff that is constantly ready. And I would point out that by volunteering, she has been doing monthly reports, but she's received no response and sending them to the board, but she's received no response on that. So they've kind of gone into the ether. So we requested the monthly. She's been doing that voluntarily. The third party is an issue, but I'm obviously encouraged to have learned that she has voluntarily done the monthly reports. So that's really where we are. We haven't taken issue with the recommended discipline other than asking that it be more frequent and subject to monitoring.
Thought there was something about you're asking for some kind of an admonishment.
Well, I think she should be admonished for her delay, but I think the board's the probation is.
Did I understand it that that was a request of yours that was in addition to the board's recommendation?
There is no admonishment in the board's recommendation, and I think there should be.
And I guess my question is just, isn't a 12-month period of probation in and of itself an admonishment? I just didn't understand what you were asking for, I guess.
I'm not sure it is entirely the same. And I am also conveying some of what the complainants expected or were hoping for from the board. And I think that it would be appropriate to advise not just this court reporter, but all court reporters that they need to be attentive to the timeliness of producing the transcripts because it causes problems.
You don't think a 12-month probation does that?
I don't think that's an admonishment. It is discipline.
Here, it's not just timeliness either. It was
The broken
reliance on,
promises.
right, reliance on the assurances that it's coming out. I've almost got it ready. That kind of thing. Because if it was only a delay, then somebody would have perhaps said, this needs to go to somebody else to be typed, something like that.
I think that the repeated promises that were broken are a critical part of what needs to be disciplined in this manner. And I think an admonishment to that effect is appropriate.
You're not asking for any time that she's unable to.
I'm not.
You know whether the monthly reports that have been voluntarily submitted are sufficient in what you were looking for, or is it hard to tell because the board staffing issue?
It's hard for me to tell because they have not been sent to me and I have not reviewed them, but Mr. Biggs has advised me of them and just showed me one this morning. but I haven't had time to study.
Why haven't they been sent to you?
I don't know.
Did you ask for them?
No. They are not part of the discipline at this point. That was just the recommendation of the board. They've been produced voluntarily. Any other questions? Thank you.
Morning, Jim Biggs on behalf of the respondent Dana Burkdoll. As you can tell, we don't dispute any of the facts in this case, and we don't allege that any of the information that's been provided by the board in this case is wrong. What we are saying is that my client knows that she made a mistake. My client knows that what she did was not right. She's not making excuses for it. In fact, what we were asking, because there aren't many court reporter disciplinary decisions out there, what we are wanting the court to do is consider some of the mitigating factors that have occurred, because in disciplinary actions, the court looks at aggravating and mitigating factors. And in this case, there were some mitigating factors that were brought out during the hearing in front of the board. One of those mitigating factors is the pandemic that hit. Understandably, it affected everybody, but it also affected my client's ability to staff, as well as what the Child Tax Credit Act that allowed for tax credit for people to stay home with their children. And that caused, in the testimony, you'll see it caused my client's staff to go from 12 to 14 people to 6 people. And that included scopists as well as proofreaders in that situation. Also, there was a death of her ex-husband. That's a personal issue with her, but it did affect her for a while, even though it was her ex-husband. They were close. The testimony in that discusses that also. And then finally, as the brief of the prosecutor, Mr. Thompson, stated, she cooperated throughout this process. When she got the complaints, she responded to them. She entered stipulated facts, didn't contest it. And the mitigating factors that I'm talking about, they're not excuses. They're just things that were occurring in her life that caused her delays. No excuse for telling the other attorneys that I'll have that to you next week. I'll have it to you. And then a month or 2 months later, if you look at the facts in this case, everything occurred within approximately an 8 to 9 month period. She's been a court reporter for 25 years. She hasn't had any discipline complaints in the past against her with regard to this. If you look at it, it's about when everything happened, and she testified that in July, she noticed her delays started, and she knew she was in trouble in July because staff was reduced in July. Her booking she got way booked up, and she was delayed. Again, does not excuse what she told the other attorneys and everything in there, but I think it's something that needs to be considered. We also discussed at the board hearing what protocol she has put into place to avoid this ever happening again. And she specifically set forth what protocol she now has in place to avoid this. Number one is I'm not taking as much of a workload. I've got people that are what we call trackers. I've got people that deal with emails. And so she's placed these protocols in place to allow this to not ever happen again. And so what we are requesting is, and as Mr. Thompson said, my client has been providing voluntarily since the recommendation came down, a monthly report to the board with no response, but that's all right. She wanted to show that I'm serious about complying with this and showing you exactly what the board requested of me back on April 10th of 2023, when the board said they wanted the date that the transcript or the deposition was scheduled, the date it was taken, the date it was ordered, and the date it was provided to the parties. And those documents do show it now. This isn't a form that was provided by the board because that was never given to my client. So she created her own that provides all that information that's been provided. So what we are asking is that the court adopt the recommendations of the board with regard to the quarterly reporting, even though she's been doing it monthly. And also, as far as the third party, I don't know who the third party would be. I mean, obviously, it should be the regulatory agency, the Board of Certified Reporters, but they're not providing any response or communication or acceptance to what's happening. So with that regard, I don't even know if that's a possibility under these circumstances or where she would need to provide those other than where she is currently providing them. I don't have anything further if there's any questions. Thank
What do
you.
you recommend?
I'm willing to recommend that the board recommendations be approved by this court, be affirmed. The one thing that's a twist is possibly where does the third party? That was one of the recommendations from the board. How do we address the third party? We've been sending it to the board, whether or not that's sufficient, whether or not they're.
Help me understand. I thought you just said that the board recommended a third party.
Well,
I thought the board's recommendation was that the reports go to the board.
they were, I apologize.
Okay.
Mr. Thompson,
The-
third
yeah.
party, so.
The
Yeah, so how we deal with that third party is question, and I'm not sure. My recommendation would be it would continue to go to the board. My client retain documentation showing that she submitted it to the board. So if not, then she can show proof that she has provided that to the board. Additionally, I would ask that the court take into consideration, for lack of a better term, time served, since she's been providing these to the board per the recommendations since April of 2023, that go towards the 12 months in which she has what the board recommended.
You heard Mr. Thompson's recommendation of an admonishment for the probation, if you will, to be tied to. Tell me, given the circumstances here, why your client should not be admonished for what happened during that night.
I think taking into consideration everything that was going on in society, taking on what happened, her practice, as well as personal things occurring in her life, that those are mitigating factors, that they, as I stated earlier, they're not an excuse. However, and the fact she's never been disciplined in the past, she's fully cooperated, she's taking this seriously, and she's done everything that she could possibly do to try and rebuild what happened earlier. I mean, she still does work for the Attorney General's office. I mean, I think this was a temporary, as you can tell by the time period lapse that occurred just by a storm that was building, and it hit, and it resulted in some actions by my client that don't represent her practice as a court reporter. However, it doesn't provide the excuses of what happened.
I understand that. I understand she regrets it very much, that she's sorry that those things happen, and she's been very cooperative. Were other court reporters complying with during the same period of time?
That I couldn't comment. I mean, I would assume so. I mean, she indicated in her testimony that she thought that they were complying with the reasonable standards. Questions? Thank you.
Thank you. Thank you to both of you for your arguments. We'll take this matter under advisement. Court is now in recess until 10:30. Thank you.